Welcome back to the Financial Literacy Project, presented by the American Bar Association Tort, Trial, and Insurance Practice Section and Thomson Reuters. This is the 7th segment of the Understanding and Managing Debt module. In the prior video, we discussed bankruptcy, including what bankruptcy is, who can declare bankruptcy, and the different types of bankruptcies that are available. In this segment, we'll cover garnishments, liens, and judgments. Please read our legal disclaimer in full. In sum, these materials and any forms referenced are intended for educational and informational purposes only. What is a garnishment? Garnishment is when money is legally withheld from your paycheck and sent to another party for payment of a debt. This is typically in the form of a wage garnishment. Garnishment is used for debts such as unpaid taxes, monetary fines, child support payments, defaulted student loans, and consumer debt. The Consumer Credit Protection Act, or CCPA, prohibits an employer from firing an employee whose earnings have been subject to garnishment. If a debt collector obtains a court judgment against you, the debt collector could garnish your bank account. Under the CCPA, wage garnishment for consumer debt is generally the lower of either 25% of weekly disposable income if the individual's disposable income is above a specific minimum amount, or the amount by which the individual's disposable income is greater than 30 times the federal weekly minimum wage. Let's look at this in more detail. Disposable income is gross income minus legally required deductions, such as federal, state, and local taxes and Social Security deductions. For example, if the federal minimum wage is $7.25 an hour, and an individual earns disposable income under $217.50 per week, which is 30 times the federal minimum wage, there can be no wage garnishment. If the federal minimum wage is $7.25 an hour and an individual earns between $217.50 and $290 per week, the amount above $217.50 can be garnished. And if an individual earns $290 or more per week, a maximum of 25% of their disposable earnings can be garnished. There are federal and state law exemptions that apply to bank account and wage garnishments. These exemptions vary by state, as do procedures for claiming exemptions. A larger portion of an individual's earnings is subject to garnishment for child support and spousal support. The CCPA does not limit wage garnishment for federal or state tax debt. Different rules apply to bankruptcy court orders. Time is of the essence if you're having problems paying off a debt. Before a judgment is obtained against you, you may want to consult a credit counselor or consult with an attorney. The homestead exemption is a legal provision that helps shield a home from some creditors following the death of a homeowner's spouse or the declaration of bankruptcy. The homestead exemption is designed to provide both physical shelter and financial protection, such as to block the forced sale of a primary residence, but does not prevent or stop a bank foreclosure if the homeowner defaults on the mortgage. Exemptions for homestead properties vary from state to state. Florida and Texas afford unlimited financial protection against unsecured creditors for the home. Most common, however, is a limit for protection from creditors that ranges between $5,000 and $500,000, depending on the state, with many states in the $30,000 to $50,000 range. The protection limit is not for the value of the home, but for the homeowner's equity in it. This is the value of the property minus the balance of the mortgage and other financial claims on the property. If the equity held is less than the limit, the homeowner cannot be forced to sell the property to benefit creditors. If the equity held is more than the limit, creditors may force the sale, and the homesteader may be allowed to keep a portion of the proceeds. Protection for the homestead property does not apply for secured creditors, such as the bank that holds the mortgage on the home. For bankruptcy cases filed after April 1st, 2019, federal bankruptcy law shields a home from sale if the owner's equity does not exceed $25,150. For bankruptcy cases filed before April 1st, 2019, the exemption is $23,675. For those who declare bankruptcy in New Jersey or Pennsylvania, a homeowner can still get protection using the federal limits, even though those states do not have homestead exemptions. Credit card companies and private student loan lenders must obtain a garnishment order through court. Government agencies can use administrative garnishment to garnish your wages without having to get a court order. The IRS may garnish your wages without a court order. Technically, by law, your employer is the garnishee, that is, the one being garnished. Liability for failure to comply with a garnishment order falls on the employer's shoulders. Garnishment orders are a matter of public record, which means credit reporting agencies can find out about them. All right, that concludes this segment. We hope you now have a general understanding of garnishments, liens, and judgments. And congratulations, you have successfully completed the Understanding Debt module. Knowledge is power, so be sure to share this module with your friends, family, and other members of your community. Empowering ourselves changes our lives. Empowering others changes our communities.